Hi everyone, and welcome back to our podcast. Today, we are tackling a topic attracting significant attention across the business and legal landscape: Agentic AI. If you work in data protection, compliance, or are developing an Agentic AI tool, this episode is for you. My name is Eleni Kyratzi, and I am joined by my colleague Tania Patsalia to discuss this rapidly evolving topic. So Tania, what exactly is Agentic AI, and how does it differ from the AI tools we are already familiar with?
Thank you, Eleni. Great question and an important starting point. When we talk about Agentic AI, we are referring to something that goes meaningfully beyond the generative AI tools most of us are familiar with, such as the ChatGPT or Copilot. According to the UK Information Commissioner Office, the ICO, Agentic AI is what happens when large language models, the LLMs, are integrated with additional tools, databases, memory, computer operating systems, and ways of interacting with the real world. That integration creates a system that can do more than just generate text. It can perceive its environment, plan, take action, and learn more from the results. Spain's Data Protection Authority takes a similar approach, but with more technical granularity. The Spanish authority defines an AI agent as an artificial intelligence system that uses language models to pursue a goal, acts appropriately according to its circumstances and objectives, adapts to changing environments, and makes decisions within its perceptual and computational limitations. To achieve this, it decomposes complex tasks into subtasks executed in a planned sequence, what is known as the chain of thoughts, each implemented with different tools and services.
That is very helpful. But what is the critical nuance for our audience here?
Well, both regulators make clear that because these systems build on LLMs, they inherit LLM weaknesses, hallucinations, confidently stated but incorrect answers, and bias embedded in training data.
Getting to the heart of the matter, what are the primary data protection challenges that the Agentic AI presents?
Both authorities have addressed this in depth, and there is remarkable alignment on the core issues, even where framed differently. First, controllership and responsibility. Organizations remain fully responsible. The fact that an AI system exercises a degree of agency does not remove human or organizational responsibility for data processing. The Spanish authority goes a step further, noting that Agentic AI can introduce additional parties beyond controllers and processors, generating complex liability change, especially where components like LLMs are provided by external entities.
What about data minimization? This seems like a major friction point. Developers often want to give an agent access to as much data as possible, so it has the context to perform better. But the GDPR requires the opposite. How are regulators approaching this tension?
Both regulators flag the same core tension on minimization. The ICO notes a split. Some stakeholders want granular controls over what an agent can access, while others argue that more context improves performance. The Spanish authority goes further. It says minimization must be embedded into the design of the agent itself. Their example: if you just need to check someone is on a guest list, why download the entire list?
That guest list example is very instructive. So, if I understand correctly, the Spanish DPA is essentially saying, think about minimization at the level of each individual operation within the chain of thoughts, not just at the overall processing level. That is a higher bar than many organizations currently apply.
Yes, and then we turn to transparency, perhaps the most acute challenge. The ICO notes that complex information flows makes Agentic AI particularly difficult for transparency, because data may be shared at different stages among different agents developed by different organizations to support different decisions. As capability increases, these systems may autonomously generate new ways of using personal data, processing information beyond what developers anticipated, seeking out new data without an individual's knowledge, or repurposing data collected for a different purpose.
The Spanish TPA frames this as a systemic problem, warning of an illusion of reliability, where the system appears consistent and effective despite the absence of solid validity guarantees.
Then there is the issue of automated decision-making. Both regulators flag that agentic AI will significantly increase the volume and complexity of automated decisions. Interestingly, the Spanish authority provides a detailed analysis of when agentic AI does and does not trigger Article 22 of the GDPR, noting that the use of agentic AI in processing may involve automation, but will not always constitute automated decision-making within the meaning of Article 22 GDPR. For an agent that merely tracks and summarizes events, it wouldn't trigger Article 22, but decision-making that produces legal effects or significantly affects individuals clearly would.
And of course, there is the risk of unintended use or inference of special category data.
Exactly. Organizations need to assess whether their agentic system has the potential to infer special category data, even unintentionally. And there is also the cybersecurity dimension. Think of AI agents as digital insiders, entities operating with varying levels of privilege and authority, capable of causing harm unintentionally through poor alignment or deliberately if compromised.
So the two regulators, the ICO and the Spanish TPA, seem to converge on the key issues. Is that right?
On major issues we have just discussed, controllership, purpose limitation, minimization, transparency, automated decision-making, they are remarkably aligned in identifying the same core risks.
But what else do the ICO and the Spanish TPA highlight about agentic AI? Are there other specific risks our listeners should be aware of?
Yes, there are. The defining risk they highlight is autonomy. Unlike standard AI that waits for a prompt, agentic AI has the agency to interact with external tools, access databases, and execute multi-step plans without direct human supervision. This creates significant tension with the principle of purpose limitation. Because these systems are designed to be flexible and goal-oriented, they can easily drift into processing data in ways the developer never explicitly authorized. In effect, as the AI's capacity to act increases, the organization's ability to predict and therefore limit how personal data is used becomes a moving target. This means it faces real legal consequences.
So after all these challenges, what should organizations actually do? Both regulators offer concrete guidance here, and the overlap is striking.
Both the ICO and the Spanish authority are clear that existing data protection law applies fully to agentic AI. The Spanish authority puts it equally plainly. The data controller who chooses agentic AI as a means of processing has the obligation to ensure regulatory compliance.
So step 1 is governance. The Spanish TPA is particularly emphatic here, calling the existence of an information governance framework that covers agentic AI systems throughout their life cycle the most important measure an organization can adopt. How about step 2?
Step 2 is to conduct a thorough risk assessment, potentially a data protection impact assessment, before deploying an agentic AI system. Not every system will require one. It depends on what data is being processed and how, but you need to think it through carefully and document your analysis. Step 3 is to minimize data from the start. So design your system so the AI accesses only the data it actually needs. Step 4, keep humans in the loop, meaningfully. Decide upfront how much autonomy the AI gets and match that level to the level of risk. Remember, the organization itself remains responsible for how the system is designed and deployed.
Step 5, transparency and traceability. Both regulators stress the need for robust logging and audit trails.
Exactly. Step 6 is memory management, managing the AI stored data carefully by separating by task, case, and user, and setting strict retention periods. 2 final steps. Take an incremental approach to deployment. Start with lower risk processing in limited cases and expand gradually. And finally, Get your contracts right. Formalize relationships with AI providers, model developers, and third-party services, clearly defining who is responsible for what, and ensuring contractual control over privacy and security obligations.
Looking ahead, do you expect the regulatory landscape around agentic AI to evolve in the near term?
Absolutely. It is moving fast, and that pace will only accelerate. Both the ICO and the Spanish authority are now treating agentic AI as a distinct category, and rightly so, because it moves beyond generative AI. It does not just talk, it does. That shift from content generation to autonomous execution is driving a real move from reactive to proactive regulatory oversight.
I couldn't agree more. We're already seeing concrete examples. Take the ICO's focus for 2026. They're looking specifically at agentic commerce, the risks posed by personal AI agents that could make financial decisions or negotiate contracts on behalf of consumers. At the same time, the Spanish DPA emphasizes that these systems can carry out complex sequences of actions, interact with multiple services, and even retain memory of past interactions, all of which may produce risky outcomes. So put simply, when AI starts acting independently, the stakes get higher and regulators are watching closely.
What I find particularly interesting is that regulators are no longer just writing static rules. Through initiatives like the ICO's Innovation Advice Service and various regulatory sandboxes, they are actively monitoring how these systems work in practice. That means future regulation won't come purely from theory. It will be shaped by real-world deployments and lessons learned.
Exactly. Taking a step back, the message from the guidance we have seen so far boils down to 3 pillars: accountability, transparency, and human oversight. As agentic AI becomes more widespread, organizations should expect significantly more scrutiny of their governance structures. The key takeaway: start embedding compliance checks now. The stronger your privacy by design framework is today, the better positioned you will be as the rules become more detailed.
That is a great note to end on. We have covered a lot of ground today, but the bottom line is clear. Agentic AI is not future technology. It is here. It is evolving rapidly. And both the UK and Spanish regulators are signaling that organizations need to be proactive, not reactive. Although this guidance is not binding in the Greek market, it nonetheless sets a direction. And as the Spanish Data Protection Authority puts it, rejecting agentic AI is a mistake, but accepting it blindly is a significant risk. The right path: evidence-based, design-conscious, and governance first.
Thank you, Tania, and thank you for joining us, everyone. We'll be keeping a close watch on this as the landscape evolves, so stay tuned for the next episode. For more information, visit www.bernitsaslaw.com or reach out to us directly.
This is Bernitsa's Law Podcast, your window to the latest legal developments in Greece. This podcast is intended to provide general information and is not meant to constitute a comprehensive analysis of the matters or to be relied upon as legal advice. It is not meant to create a lawyer-client relationship. Legal and other professional advice should be sought before applying any of the information in this podcast to a specific situation.